And I said, why were you not afraid? He was like, he was hired up. And I said, what is hired up for the jury? Can you explain it? He said he was high. He was a joke to me at that point. It was just intense because I'm dealing with a white male state's attorney who used to be a defense attorney, I guess. And he knows he's a crackhead, but he just didn't care because he just assumed he had enough to make this work. And he said if the defense can't ask a question, if they don't know how to ask questions, then they should go back to law school.
Whoa.
And yeah.
This man told the jury, you should go back to law school.
Mm-hmm. Yeah, he didn't even see it coming. I mean, he got frustrated a little bit because I guess they said, how do you know it's him? Did you see him? He said, well, it had to be him because that's who I just was beefing with. Right? Like he never says yes ever before the day we get on the stand. So now you know, but you didn't know.
You essentially allowed him to get on the witness stand and tell a bunch of lies that you knew were contradicted by the evidence.
Now, we had never heard that before. Allegedly, now this person who was in the home is now an eyewitness to the actual shooting, but they don't call this witness. He never gets called. So that was a gold mine for me because you got an eyewitness and you never even question him. We don't have no video of that. I said, you never interviewed him, right? Well, he never would show up. And that's what probably made this case real tricky because horrible experience to look at my client come back to me 3 times and keep coming back over there saying they're not going to let us get this in.
So even on direct, the judge still doesn't let you get it in.
In my mind, this is all I have left is they don't want you to see something. I've asked the question 16 different ways. They have objected. We've been to this bench 16 times. Something they don't want you to see. You're going to have to linger on why. I don't know. I think I would always feel like y'all lying. Like any witness for the state, any officer for the state, y'all lying. And I'm like, shut up.
That's right.
The officer who I got the video in of where my client goes in and out, he could not say that was my client because he can't identify my client from that video. There's no clear face of this person. So nobody is able to ID it.
Couldn't win an objection. You knew damn well this judge wasn't giving you an acquittal.
The state can't even disprove me telling you that he never came out because they didn't even allow you to see that. I just kept saying the state put on a narrative that is representative of the case they want you to see. There were things that the state just didn't want you to see. And unfortunately, that's the nature of the game.
Hey everyone, welcome to the Iron Gavel. I'm Chris Washington, a personal injury and criminal defense lawyer with over 17 years of courtroom experience. Bi-weekly, we bring gripping true stories of justice, strategy, and humanity from inside the courtroom. Today's story is one of high stakes, sharp tactics, and a verdict that changed a life. Today's guest is attorney Yladrea Drummond, who took on a case where her client was facing an attempted murder charge. She was able to secure a not guilty verdict in an extremely conservative county where defense attorneys rarely win violent crime cases. In fact, it had been 5 years since the last not guilty verdict was obtained in a violent crime case. The deck was stacked against Yladrea's client. However, she never backed down from the challenge and was able to free her client. She's licensed and fighting for clients in Texas, Maryland, and Washington, D.C. But before we unpack the courtroom drama, let's get to know Yladrea. So tell us, Ms. Drummond, what inspired you to pursue a career in criminal defense?
I had my first criminal defense case when working at another firm. I was doing a lot of family law, and it was the first one I guess they had in a while. And so it just naturally came to me about what to do next steps because I've always been a person who, coming from more of a political background and fighting for people's, access to justice, it just went hand in hand that I obviously needed to be able to do more impactful things for people whose lives are on the line. Other cases, obviously, everything's important, but we're talking about literally somebody's life in your hands in a sense, depending on the case. So I feel like it was my purpose. So I should be doing that.
Where did you grow up and how did that shape your views of justice?
So growing up in Houston, Texas, with a lot of heavy ties to Louisiana, but it's really, of course, racist in the South. Also very harsh punishment. We have the death penalty in Texas. And also I had some friends who, watching them grow up, they would get in trouble and for the first time and do 15 years, 10 years on their first offense, just because it's such harsh punishment in the South. Oh, even as juveniles, I represent juveniles too up here in Maryland where I'm at now. And it's a slap on the wrist. So growing up knowing everything was so harshly punished, we were had to act a certain type of way. We always had to try and do our best because anything could put you in jail for a long time, or other than that, be dead, right? So I didn't grow up in a poor family or anything like that, but I grew up around a lot of, people seeing a lot of things. But just the South in general, it'll shape you into knowing like justice is not for everybody, but it can be if we step up. So
What city in Texas did you grow up in?
I was in the Missouri City, Texas area, which is inside of Houston, born in Houston, but raised in Missouri City, Texas, or Mo City for my young folks.
So, what would you say your mission is with respect to doing criminal defense work?
So I like to call myself like a justice warrior. But my goal is to restore people's lives, like restore their names, restore their freedom, just really honestly pouring back into people, no matter who you are, showing up every day. My mission is to basically work as a restorative justice person. I call myself a justice warrior. In law school, the slogan is seriousness of purpose. And so my mission is to make sure that I am always serious about somebody's life, make sure that I can restore them back to a place where they can grow, do better, and go on and be great in life. Whatever the path is, my job is to make sure that I do it to the best of my ability to restore what justice should look like. If it's going to be a guilty, we're going to fight for that guilty because you don't give up. Our mission is to fight until we can't fight, not just to free just everyone. It's to literally show that if we all do our job, the justice system should work exactly how it should. My goal is to restore justice.
Justice warrior, I like that. This is one of the things I ask a lot of guests. There are a lot of criminal defense attorneys, right, in Maryland and DC where you practice. So, what sets you apart in the field of criminal defense work, which would make a member of the public say, hey, Miss Drummond is somebody I'll consider if I'm ever in trouble?
Yeah, so in Texas, I would say there's a way more criminal defense attorneys that look like me. Out here, not so much. They have a lot of law schools in DC and Maryland. And I would say a lot of people don't like criminal defense. They don't want to do it. They're scared of trial. I think the main thing that sets me apart is that there's probably, outside of the public defender's office, a handful of actual private criminal defense attorneys that are Black women. I would say the handful will go to trial. Most defense attorneys in the DMV don't like trial. Here's why a friend of mine calls them ushers. They usher them to the state. They just usher them to a plea. No shade to many people, but they don't like trial. I literally am not scared. I start every case at trial posture. I would love for you to go to trial. If we have a case, I encourage my clients, like, you can at least beat half of this. You don't just lay down, right? So because people know that, I think they like that I'm not from here. So that sets me apart. I don't talk like them. I don't think like them. I didn't go to school out here. So I don't have personal ties to anybody here. And so it's never really that many conflicts. Like they always do that. Anybody know the defense attorney for this client? Nobody ever knows me. Like if somebody knew me, I'd be shocked. I think what sets me apart is because people know that I'll fight in any county. I don't care what county it is. I'll take it to trial. So
okay, that's great. We need more of that. I was talking to a gentleman yesterday, and one of the things we were talking about is lawyers becoming jaded and just ushering clients to a plea deal because they simply assume the person is guilty because that's what they see in a lot of cases. And that's unfair to the clients, and as a lawyer, you need to pause and consider what's driving you to that, giving away your client's presumption of innocence. So the case we're going to talk about today, give us like a big overview of the case.
So this takes place in St. Mary's County. It's very conservative. I will say that it was a heavy area where people who supported Trump, and that's not to add any, policy to it, but simply they support Trump. They support capital punishments. They support harsh punishments. And it's not wrong if people are doing the things. We're talking about giving 6 life sentences, like they'll give it to one person. So the overview is this county is very conservative, heavily more white than any other race. And this particular place that a lot of the crimes happen, especially the violent crimes, are is in like a very insular area that's very heavily people of color. And so this case, my client is charged with first degree attempted murder, second degree attempted murder, and all of the heavy assaults going down. And they only have the two levels kind of on the attempted murders. And attempted murder carries a life sentence. It was alleged that he had, of course, shot somebody's finger off or shot him in the penis area. I'll say that. Somebody from an argument. But overall, it was just intense because I'm dealing with a white male state's attorney who used to be a defense attorney, I guess. This is his first trial, I guess, in this county. He started this county 6 months ago. It's his first trial in this county, but it was my second. I had previously it was my third, but it was the second win. So you can't win in St. Mary's County. That's what they say. You can't win a violent crime. You might as well just, give them to the state in so many words. You might as well get them a best plea deal. But in this situation, they offer top count plea deals. They only offer the top count and they say free to allocute. So they're saying you go from 0 to life. Just, we're going to plead to something. We're going to read these facts off a piece of paper. The judge is going to hear it. He's going to sentence you between 0 to life. My client was like, no deal will be enough.
What does life mean up there?
It's been a debated thing that people are saying that it's up to like 65 years. I have yet to read that, right? So for what I take it as, it's actual life, because they still do the life without parole. And I think people are sometimes eligible on a life sentence at 20 years. If they're eligible for parole, they can ask for it. It's called a second chance, but the likelihood is slim. I mean, I consider a lifetime, if you're 30 years old and you guys, even if it's 65 years, that's your lifetime, right?
Yeah,
so my client was 32 years old, so he was looking at a lifetime if he would have gotten life.
All right. So why is it important for the public to know about this case?
It's important to know about this because I was up against a place where literally 5 years, we're saying about 4 to 5 years, where there's been nobody on a homicide case in particular, and even violent crimes, but a homicide case in particular in this county, not one person has been found not guilty. They maybe have beat the top count, but that still leaves them like second, degree murder or attempted murder. They don't win all the way down. It's important because the tides are turning. I'm a new wave of a type of attorney who I don't stop. So I make sure I really focus on jury selection. It's important to know like every piece counts of a case, but also, it got really ugly between, of course, the state and myself for no reason. So it's shedding light on the fact that, sometimes unprofessionalism could lose a case for somebody. And it's just not good business. Yeah. So it's more important for people to know that, we are supposed to be upholding the law. In this case, you had a lot of people who want to care about justice. It's a person who said they care about justice, yet he chose to take, personal shots at me directly in open court in front of the public. And that's just not good for anyone. So it didn't work out for him.
I know what those are because we talked about them in great detail on our discovery call, and we're going to dive into them a lot. I want you to share that. Sometimes we deal with the most unprofessional people who are, not upholding our justice standards. So your client, when you first met him, what was his emotional state, and what were some of the doubts and fears he had and that you had?
So I probably had more doubt than him. He was like, as soon as I got on the phone, I talked to him the first time on the phone because he was already incarcerated. So he's been incarcerated this whole time. He was like, I have a prior. I'm not violated on that prior. Hopefully this works out. I just came back home. He had just lost his mom. In fact, this is allegedly over an incident about his mom's passing. So he didn't even get a chance to fully grieve that. But he was very actually like, from the beginning, like, hey, it's a trial. And I was like, oh, okay. You sure you want to? He was like, no, it's a trial. He was like, because I didn't do this. And also he was like, I know they will never have any evidence to prove anything here. A lot of times they don't. It's just that people don't go to trial, and I want to go to trial. He was like, if it doesn't work out, I don't care. I'll have to go on appeal. And so that gave me the confidence to say, this is somebody saying, I don't care if I lose. I'm going to fight for myself. And so I instantly turned on the gears. I was like, okay, it's a trial. And it never went from there. I mean, they would come to us. They would try and offer us a plea. He was like, I don't care what plea it is. Tell them no. So I had always knew it was a trial. So most murder cases or homicide cases take a long time. You don't go to trial right away, right? I got this case end of January. I went to trial in May. So there was hundreds, I'm talking about hours of video. My discovery took up 2 terabytes. So it was a huge case. He's a very smart individual and he was very involved. So he was like, can I get the discovery too? When my client said yes, I'm like, okay. And at this place, so it's already like from my office about an hour and 15-minute drive, right? So this is a very far out. I'm not even close and I'm having to go do these visits. I had asked the state's attorney to put his discovery on a disc. Typically they don't, but the state at the time, which is why I thought everything was all good, he put it on a disc, but I had already made a copy from the one I had been sent. And I went up to the jail, gave it to the jail. The jail lets them go and watch their stuff every day if they want to. So he was in the library or wherever they were watching it every day, telling me, oh, look at this part. So he's like co-counsel. So I'm like, all right, I'm a solo. I'll take it. But he was in a good headspace, surprisingly, I guess, because people just know you get in trouble in St. Mary's, you're either cooked or, you're hoping for a miracle. But for the most part, they all still take it. They don't all take it to trial, but they wanted to take it to trial because they said that enough is enough. Because the community had did this outcry expressly calling out the courts and the state's attorney's office saying, y'all are not harshly punishing violent crimes. And so when they weren't getting what they wanted, they were at least making sure that they would get in that jury and they would convict. So he was always like, it's a trial. Shockingly, he wasn't sad. He was just like, let's go.
That makes your job easier. When you know the client is locked in, that helps you lock in even more. Give me like a clear play-by-play of the actual incident that he was alleged of committing.
So allegedly, they're saying that on, I guess it was November 9th, 2024, he was alleged to have shot intentionally, of course. This happens at, like 6 o'clock in the morning. So the night before, there was what's called a benefit or a memorial for his mother at this place. He's there. He leaves. My client's there. He goes home. This victim is not. The victim comes to my client's mother's home where he's at. And he allegedly, he's there just to check on them because he said they're cousins, that he's cousins. So at the home is my client, his brother, and his uncle, and then the victim. And so the victim says he's like, oh, I'm just there to check on him. Apparently my client's a drug dealer. That's what he's saying. My client is a drug dealer. And my client said, you owe me money. You want some more, you owe me money. He was like, well, I could give you 5 or something. This is the victim. Allegedly, my client pulls out this knife and like swinging it at him like a crazy person. The guy runs out. My client allegedly follows him. But then the victim says, my client disappears. And then an hour later, at the CVS, like that's close by, I guess the victim standing at the pole, and allegedly he says he sees somebody walking down the street that doesn't look like my client, because my client has these long dreads. He's wearing something totally different. This all black person comes out, stares, but then just goes and sits across the street somewhere at some home, waits 20 more minutes, and then comes across the street, says, I got you, some bad words, and then starts gunning him down from the street, shoots off a finger and hits him in the penis area. And then they said, allegedly, that's what my client did. I mean, the story didn't work out for them, but that's what he said. They're saying he did. But the person who allegedly shot him was in all black. But when he was with my client earlier, he said my client was in white.
That's an overview after you get the discovery. So I know at some point you get the discovery, which is the evidence they allegedly have against your client. That's what discovery is. So when you review that discovery, what did you see that you thought in that may have been problematic for you?
Honestly, nothing in the discovery was problematic for us. The only thing was I had to tell my clients, yeah, he made all these different statements. Basically, they had nothing. I'll put it like this. When I saw the video of where his mother's home was, the neighborhood is almost everything is so close where this all happens. But the apartments that his mom stayed in, there's a video directly coming from the front door and you can see who comes down. He had pointed out to me who it was in the video. So you see my client come out and then you see him go back in. There's another video. You see him go walk off somewhere and then he comes back, gets out of a car and goes back in. And that person has on a white shirt, black pants, long dreads. That's it. But then you don't see my client come back out. But the narrative that the victim tried to say was that he probably changed clothes. So that was the only reason why that video was a little bit like, let's see if they're going to believe that somebody who came back out in this all black, if that's you.
Let me ask you, because I see this a lot, and this is something the public doesn't always appreciate. You get this discovery, you looking at it, and you see a complete lack of evidence to convict your client. Explain to the public why, in a situation like this, why that happens and why your client is still charged. Like, what's the difference? What does it take to get somebody arrested versus convict them in court?
Yeah, so circumstantial evidence is all they need to them. Probable cause is not that hard because when they go before the grand jury, they can use anything to get them indicted. So he being a person who had had a prior felony of a violent crime, which is assault of a stabbing. Some years ago, he did like 6.5 years for that. And since it's such a small community, the officers know like who people are. And he had been the person who found his mom, dead in the home. So he made the call. They just made this assumption that this had to be true because of his background. He had just gotten home. The guy had pointed to that, like, oh, he just got back. This is who did it. So when you look at evidence and you're like, dang, there's a lack thereof, it sucks because people can just get indicted strictly off of what, hearsay. Anything that is said gets you indicted. But a conviction requires that to stand up. So like whatever you say before or whatever's written, it doesn't really matter if it doesn't correlate to the day of trial. Trial is absolutely different because they have to now stand up on what they said before, or that evidence literally has to point to it. So a lot of times if there's no evidence that can actually build the story in front of somebody else, like a jury or even a judge, really, then it doesn't stand up. So you can get around a conviction if nothing matches up, right, in real time. And I just saw evidence that was shaky at best. I went to the state and I said, hey, this case shouldn't even go forward. Why are we here? You could let this case go. And he was like, you're going to lose.
See that right there? I have a huge problem with that, and a lot of the guests I interview, we talk about that. Your job as a criminal defense attorney is to defend your client from start to finish, innocent, guilty, or somewhere in the middle.
Right.
You're obligated to stand by the person and for them. The prosecutor's job is different. They're supposed to prosecute people who they believe are guilty beyond a reasonable doubt. But if they don't believe that, they are supposed to dismiss the case. They aren't supposed to, I'm not sure if this guy did it or not, but I think I can win this case, so I'm going to take it to trial anyway. That's actually not their job.
That's not. No. There's actually a case that they have, and it was on the wall of one of the state's attorney's office. That's why I was looking to see on my phone if I still had it. But essentially the case talks about it is the prosecutor has one of the highest oaths, right? And the prosecutor's job is not just to basically, they ensure justice, but not by basically weighing somebody down, or you can't just try and kill everything you see. You have to balance that by saying, I've assessed everything and I'm going to prosecute it zealously, whether it's a no bill, like I shouldn't be doing this case, I should drop this case after reviewing everything, or if going hard because you truly believe, even though something is highly circumstantial, because circumstantial works, it has to be enough to say, I believe this is actually worth it. Not just because you can or you just want to convict. A lot of people do it on the conviction, and that's scary. Like, it's literally just, I want to convict everything. If it came here, it had to be true. And they instantly say, well, if you know your client's guilty, why won't you just tell them to own up to it? And I'm like, if they were guilty, prove it. First of all, prove it. And if they are guilty, it'll come out through some kind of, if you have the evidence you say you have, then that's that. But the state extends to the officers too. And I think people fail to realize the officers are an extension of the state. So it's their job to make the state get what they need. If they don't have it, sometimes they do the first charging document and they overcharge. The state should take advantage, and say no, or step up and say that can't be charged. They go with it. They will go with it because they just want to win. And they had to be guilty.
So we get this discovery in this case. What are the steps you begin to take to break apart the state's case?
So I always tell my clients, they laugh at me every time, but if you ever seen Power and he says, whatever Ghost did, just know he did that. Like whatever they say he did it. I tell my clients, I start from them being guilty and then I work backwards. I always write down every single element as if I haven't seen it before, especially on the top count. I look for where I see evidence that can match up. And so I'll do like a evidence mapping type of chart to go through and say, okay, if my client was guilty, then they would have to meet these. So I look for what I think would make them guilty. Like, what if I were a prosecutor, how would he be found guilty? And so I go through the elements, I look at it, and I'm like, okay, they don't have this count. It's okay, got it. Even though they say we're not in the proving business as a defense, I don't ever take that serious. I don't believe people think it's innocent until found guilty. I think it's guilty first, then you're innocent. So I start at guilt and I work backwards. And if I get to a point where I'm like, this might be bad, like this could be problematic, then I still try and find a narrative around, as a real person, what would I believe?
Was there any video or forensic evidence against your client?
No DNA, no fingerprints, because there was no gun. That's the first thing. And there was no video of there was video of the scene. There was just nothing on the videos, as in you don't see any of the shooting or anything like that. So nothing found in the phone. There's nothing.
So help me understand, how is your client linked to this shooting? I know we got the victim saying it was your client, but other than the victim saying it was your client, there's no scientific evidence, no DNA, no video, no pictures, nothing else connecting your client to this crime, right? Is that right?
Nothing.
And the alleged victim is a known drug user, right?
Definite crackhead.
So that's it. Your client is prosecuted and facing life in prison because of the statement made of a known drug user, right?
Yep.
And the prosecutor still wanted to take that to trial.
Yes. And the problem with that is, so this prosecutor is not from the area either. So like I said, he's 6 months in, and he also had just basically gotten a transfer where he was going to be going from the state's attorney's office in St. Mary's. He was doing guns at first, by the way. He's not really on homicide. So they gave him this homicide because he was going to homicide in Baltimore City. So he needed to try a case, and it had to be a homicide. And this was the one. Well, he knows he's a crackhead, but he just didn't care because he just assumed he had enough to make this work, right? Like he had, I guess, a narrative. I guess they're saying, because it was alleged that the victim said to my client, I'm going to come back and shoot up your dead mom's house. So I think they were trying to build this motive that my client is just so angry and that he's gone to prison before for an assault. But that has to come out at some point, because the gun charge was use of a firearm with a prior, so because of the prior, they have to bring that in. So they will know he had a prior violent crime. So he was, I think, banking on the fact that they would think, okay, once he's done something before, it's not far-fetched. So right. That was the reason why he went forward. It's crazy he didn't indict the case. And when speaking with the prosecutor who indicted the case, she was like, I didn't think y'all were going to trial. That wasn't a good case. But he needed it because he was going to the homicide unit. I guess he needs to show them he could do a homicide.
He didn't show him in this case.
He didn't show them at all. And I hope he does not do that in Baltimore City because they deserve good prosecution out there. It's a different area in Baltimore City. So
let's go to the trial. Your defense is it wasn't my clients. It had to be somebody else, right?
Mm-hmm. I'm a gray area defense, right? Like I don't never just be like
gray area defense. What's that?
Yeah, so it's like I don't definitively do the whole like that's my alibi, right? Like I might go have them investigate an alibi, but not use it as like my client wasn't even there. I'll do this whole like, was he there? If so, where was he? Like, or this whole like, wait, my client, I never say it definitively in opening that my client wasn't there because I don't want to lock into something if I have to shift gears in the middle of something. So I'm not going to say, oh, he wasn't there, unless I know for a fact my client wasn't there. But if my client wasn't there and y'all checked out the alibi, my expectation is that the case got dropped. When I give you an alibi and you don't drop it, I never can say, oh, this is it. So my internal defense was, yes, it's not my client, couldn't have done it. He wasn't involved. Like that had nothing to do with it. But really it was this like, okay, well, whatever y'all say it is, it isn't. That's pretty much what my defense was.
Let's start where cases start, and that's jury selection. Knowing what your defense was, knowing how their case was, how they thought they were going to meet their burden, what did they do and what did you do in jury selection to secure a jury that you thought would be fair and impartial to your client?
I'll take it a step back. When I first came, I just started trying cases in January in this county. Just started taking them on really, like I picked them up last year, some of them in December and November, and then I just started really trying them. But when I started getting these attempted murders and these home invasions and violent crimes, I filed a motion for change of venue. And that motion for change of venue was not your orthodox motion for change of venue saying like, oh, because they basically only look at publicity. That's what they look at. But I filed it based on community bias. And I said that this community has an outcry for violent crimes and they convict 100% of the time on violent crimes and that they cannot get a fair trial in this county at all. And so I argued it in front of one of the judges and he reserved on it. He said, if we go to jury selection, we can't pick a jury, then I'll rehear you on the motion and we'll decide if you're right, because he was like, you're onto something. Most people don't get that far with it, a reserve or like even get the chance to argue that. But it was a new one. I had put charts. I had all these things in here saying, oh, y'all, all these comments. I had put every conviction that they had on a violent crime, what sentencing they got. And it was a long, like 17-page motion, rather long. And so that was before we get to jury selection, and I knew I had that in my back pocket if I didn't find a good jury. But this is a PC 20 case homicide. I get 20 strikes. They get 10 from the state.
So we're in jury selection And I think you said you get 20 strikes and the state gets 10.
Right.
Most places it's 12, 12. Like they get 12 strikes, we get 12 strikes. But tell the audience, what are peremptory strikes?
Yeah, so peremptory strikes are just the ones where you get to go through and, whatever we don't want, we don't want the person, we go through, we strike them off and tell, the clerk, hey, please seat or thank and excuse. And that's pretty much where we go with that.
There are some limitations, right? And I'm
There
sure
are,
that's
there are
applicable in, is it St. Mary's County?
It's a U.S. thing. I think we all know we can't do it. Is what the Batson they'll when they can challenge us for if we're doing it based on bias, like skin color, race, gender, specifically, even religious. I would say anything that in a constitutional issue, you cannot do that if it's any type of bias, and they can prove it.
So that's the only limits on peremptory strikes. Other than that, you can just strike up to 20 people and you don't have to explain to the court why you're striking them. But that's different because they have something called cause challenges. And what are cause challenges?
So causes are like when we can prove the bias possibly of the actual person or prove they can't be fair and impartial, or it's a cause just because they have a very big conflict, like say they can't be there for a certain day. Sometimes the judge will do that anyway. They see it, they're like, okay, we've asked them all because they're not going to be available for these days. It's a very valid reason why we're challenging the cause issue.
So you can have people removed with cause challenges if they wouldn't be an ideal juror for the case based on something going on in their life or their thoughts on a particular issue in the case, right?
Right. And you would argue those as well if they don't agree, because they'll ask, what's the state's position? Or if they do one and ask, what's my position? We could argue, we typically do it at the bench or outside of the jury saying we can't have this juror because of this. They'll give their reason why. Most times in the end, especially in this county, it's based on can they still be fair and impartial based on the evidence themselves, or they'll do this thing where they say, do you just want to push them to the bottom of the list? Because we probably will never get to them anyway if they're at the back of the list. And at that point, we can argue the cause again if we need to, if it does get to them.
So tell me about the jury, the makeup of your jury. How long does jury selection take, and what's the final makeup of the jury?
For the most part, most of Maryland, they just started a new pilot program. I don't know, and I'm almost certain it's different most places. Most states, it is attorney-led voir dire, and so which is jury selection. And so that attorney will be able to ask the questions themselves. Like you prep them, you don't really have to share these questions. You just go do your questions. Well, in Maryland, they don't. The judge reads the questions, so we have to prepare them in advance. We submit them to chambers or through MDEC, and then we literally have, in this county, you come early, you go into chambers and you discuss them, and we can go back and forth if they believe our question is a problem and all these different things. But yeah, it's totally different. Like if you're in DC, it's not like that. If you're in Texas, it's not like that. Most people, they don't know your questions. You just get to do your thing. You answer some questions among everybody else. You know how normally, like somebody will say, oh, well, how many of you feel that way? Well, they don't have that. So they have to come to the bench, and it's always at the bench. We go up there and we have to listen and ask questions. We can do things. So it kind of is limiting. They have a new pilot program that has now expanded voir dire to where they're going to have some counties were piloting the attorney-led, and maybe a questionnaire was different. I don't know how the results ended. I was in one of the counties that did it, but I wasn't in the judge's court for the trial that got to do that. But basically, it limits you. I'm going to say that, then I'll get on to your question. Sorry. But it's limiting because you don't get to actually hear from the people themselves how you want to. People will respond to other people's answers and be like, oh, I feel that way too. You can kind of weed way more people out to say, oh yeah, this is not looking good. But there, it's like the same questions. And in particular, they argue you down on questions. They don't like your question. The state will be like, why would any defense attorney want to ask that? And it's like, it's not about that. Why would you want to do that? You wouldn't even know if you were in another state. So the privilege of you getting even a say in my question is crazy. And every time I put questions, I ask like really crazy questions that people don't think have anything to do with it, but they matter to me because I'm looking for a certain thing. I'm trying to see, do you care about this? How do you feel about guns? How do you feel about violence? But even more so, just where does your mind go? How does it go on a topic, right? What do you think? But they were weeding those out, so I was very limited. And so I used about 14 of my strikes. I didn't even have to use all of them. But the state was exhausting theirs because I knew he was thinking like a defense attorney because he was a defense attorney and he was trying to stop me from getting what I wanted. But we actually I would say when they came in, they brought in about 93 people. Out of the 93, may have been 20 people who were people of color. So this is majority, white. But it was so funny because they were standing up and they were like, I'm a proud person who's about reform. And, it was shocking. Some of the ones who would stand up, you would think you didn't know, just you can't really judge a book by its color. And that's why it's important to not have the bias.
That's
And
right.
that's it's important. But a lot of them were for like, oh, I've never had a problem with anybody with a last name named Harris. Like these are just random things that were coming out saying that we weren't asking for.
Oh,
So I
wow.
the selection was going to be decent. I said, really, I can't lose with majority. But there were some that my client, he would stay back and watch, keep looking at them as we would approach and kind of like get a feel for who he would hear answer. He was very involved. And so he had already told me a list of people. He was like, no, these, if we get to them, strike. I listened to my client. I had one case. I've lost one case last year. And the juror who my client did not want is the person who ended up being the foreman. And it didn't work out. And I should have listened to him. But I thought my judgment was better on that. But I should have, because your clients, it's their life. They have to be involved in the process. I struck the ones he said he didn't want.
The lawyers I know who do the best in jury selection, they encourage their clients to provide insight and input because, a large part of really what the client is doing is observe. He or she should be observing the questions that are being asked, how they're being answered, but more importantly, things we sometimes as the lawyer can't do by ourselves is pay attention to people's body language when, you're up asking a question or at the bench, and he being willing and able to keep an eye per se on the audience help in his own defense.
Right, it did. And so the end up makeup, and I'll say I've had 3 jury trials in that county. I've only had out of all three people of color actually make the jury. The first
Three
one
total in 3 trials?
total in 3 trials, and 2 of them being in the same month. So the first one, it was made up of all white with a active sheriff from that county on the jury that I allowed to get on that jury for a reason, and we won. And that was the first case in there for a violent crime where they were like, oh, this girl just won. That's almost unheard of. And the officer said, I just didn't believe anything that the witnesses were saying or the state. And that was cool to me because I thought, shoot, it's a very police heavy community. Like everybody there's either military police or because it's by a base. And so, or very much everybody's married to a police officer. So you have to kind of play kind of nice with the police in terms of your questioning, but also you just have to navigate that space. So that was that one. Second one had maybe 2. And then the third one, we had one black guy on there. That was it. Everybody else was white.
For the case we're talking about, this attempted murder, there was one minority, one black person on the jury.
Mm-hmm.
What we get is, and this is maybe especially true for black lawyers, but even the white lawyers I know who do criminal defense. A lot of people assume that you have to have like people that look like your client. And I tell people sometimes I strike black people. I'm not going to pick them just because they're black. What about the jury makeup? Even though you had only one minority on the jury, what about the jury makeup made you comfortable that you had a jury that was going to be fair and impartial?
So it was the way they would answer the crimes when it came to their experiences with officers, or like if they have ever had a family member who has been accused of something, charged or convicted. I really listened heavy to how they feel about the system. In fact, there were some that during jury selection that could not be impartial towards the state. Like they really were like, I don't know. I think I would always feel like y'all lying. Like any witness for the state, any officer for the state, y'all lying. And I'm like, shut up. I want these
That's
people to
right.
shut up. Like talk, and I'm like, but you'll be fair, right? And I'm like really trying to ask these questions. But ultimately, like 3 of the ones I was like, dang, I wanted this person. They got struck off of cause instantly. They kept saying, no, I don't think I can. I'm like, whatever. But the rest of them, they were answering questions that led me to believe they were open-minded and that they were going to pay attention. They were like, I don't just believe anything. But a lot of them also had family members who they didn't believe the system worked out well. They fair and impartial, but they were just like, I'll listen to the case. I'll hear it out. You have to prove your case. So every single one of them kind of gave me that you got to prove it. There were like 4 that made it. I was iffy. But, on the defense, we only need 1. I don't need 12. So I only need 1. So I felt good that the rest of them, it was enough of them on there that I felt like if they heard everything, they would listen. Plus, we're in a county where there's a lot of engineers, neuroscientists, like a lot of people who are very mathematical. That's dangerous for a state's attorney. And they couldn't get around it because him being new to that county, him not realizing the people who are on the list. We get the list, and I saw most of their professions were like engineers and this. I'm like, oh, I don't care which one really gets on the list. They're going to be paying attention because it has to make sense. It's a mathematical equation for them. They're like, it's not adding up. And I'm not going to go if it doesn't add up. So I felt strong. I was like, okay, well, I mean, I did one with the all-white jury. In fact, the case where I didn't listen to my client about that one juror, that was an officer that I put on there trying that theory. But it was 9 Black people and 3 white people, and he lost, right? So I'm like, it's not about the color a lot of times, it's about how they think. And I like to see, how do you think about certain things? Like, I love the ones who are like, oh, I like guns, blah, blah. I'm like, all right, you probably in, all right, like, cool, like, this works, I want anybody on here who either doesn't have a problem with the fact that there was a shooting, that people shoot guns. They don't automatically think you're a criminal because you have a gun. And I think you have to look at those questions that pertain to the case and see in their minds, everybody on the jury, I was like, okay, I can deal with this. In fact, I was kind of taunting him by striking people. One person I really wanted, I struck him because I knew he would then try and strike the next person, and that's something I didn't want anyway. So I was playing the game of what I thought he was doing, and so I would strike if no matter what.
So we get through jury selection. After jury selection comes opening statement. What does the prosecution say in their opening statement, and how do you deal with whatever they say in your opening statement?
So I always come prepared with a theme of what I believe is going to happen. I never oversell. In this case particularly, I kept struggling, like, which one am I going to go with? What I'm going to do? The state opened by, of course, they tell the story, they paint the scene, and then the state says, it was this guy, he's the person, he knew him, this is his family, and he still did it anyway because he wanted revenge or something like that. That was their narrative. And then I was like, okay, I took a little bit of whatever they said, but I don't ever use their words in their opening on my opening. I stick to my narrative because I am in control of only one thing. And right now it's this opening, and it's not evidence, but it needs to be important. So I tell the jury that dog ain't gonna hunt. I'm like, I'm from Houston, I'm from Texas, and I'm gonna let you know that dog don't hunt. And you're not going to see this. You're not going to see a gun. You're not going to see my client. You're not going to see any video of it. You're not going to find any DNA. I'm literally just telling what you're not going to have. It's going to be a lot of knots. And I think I did say, because the state said, this is going to be a 2-day trial. It should be very short, very quick. Like, it should be done. And I was like, well, I don't know if it's going to be short or not. I don't know if it's going to be long. I said, but I do know that within whatever time frame, the dog ain't going to hunt. And they don't have it. And so I just simply kept saying they just don't have it. My client is alleged to have done something, but that's my client. They have nothing to prove that my client did anything. This is guesswork and patchwork, and that's what you're going to see. So I went with that. I made it short and sweet. And when you say that dog ain't going to hunt, you got to have a real strong case behind it. Right. Like, you better come strong. And so
you don't want to say that dog ain't going to hunt. Mid-trial, you have to find a way to shoot the hunting dog. That's not good.
And that's what probably made this case real tricky, because that's the first time I ever chose that theme. I normally stick to something a little bit more, I don't know, something totally different. But I was like, I'm going to try it. And so that was a very interesting ride, because I didn't realize how much weight comes behind saying that dog don't hunt, I ain't going to hunt. Just too much pressure.
So after opening statements, I'm assuming you feel good about the direction the case is going, or at least how jury selection and opening went. And then we get to direct, where essentially the prosecution calls its witnesses, and then you get to cross-examine those witnesses. So let's start with, who were some of the witnesses, and we don't have to hear about them all, but who would you say were some of the most important witnesses the prosecution called in this case?
They did have one thing. They did have a piece of evidence, but it still wasn't good. It was an identification. So they called the officer who did the identification, like with the photo array. It was important for them. Those two are the most important for them. And I think they called my client's brother, which ended up being a witness that could be for either one of us. So that was who they called.
So let's
But they got 4 people, but those are the key ones.
Those are the key ones?
There was one more. Can I add that in? The person crime lab technician, the one who comes out to the crime scene and they take pictures. Crime scene. They came to the pictures of anything that could have DNA or fingerprints on it, which were the bullets and then the hole with the blood. They were important.
Who did they call first?
They called the victim.
All right, take us through his testimony. What did he say on direct, and how did you deal with it in cross?
So on direct, he said that he definitively knew it was my client. He was there, I guess, to buy drugs. He wasn't saying that in any of his other statements, but he said he was there to buy drugs from my client. And he said that my client was like, you owe me. And he said that he was just like, my client was tripping. My client was all over the place. He describes who gets him out the door, which is my client's brother. He said my client's brother woke up, came to the front, and was like, you tripping, pushes him out the door. And he never says what he said to them going out, other than he said he called my client, a B word. And he was like, oh, you're this. And he walks out, right? And then he says later on, or my client swings a knife at him inside the home. He said it was a pocket knife, and then he leaves. And then he said it was an hour later. He says definitively, I saw him coming down the street, go sit at this home and watch me from across the street. And then he came out and said, I got you, B word, and boom, shoots 10 shots. That's what he said on direct. Oh, and he said that he is no longer on drugs. And he said he's no longer on drugs and that he's clean. He's no longer on drugs, but he was there to buy drugs. But he hadn't done drugs before that in a long time. That's what he said, that they were cousins. And so that was his direct. That's where he stayed. So
after the prosecution finishes, they tender the witness to you and you get to cross-examine him. Take us through your cross-examination of the alleged victim.
I started in the home. So I walk him back through it. I'm one that will lock you back in. I try not to do too many open-ended questions, but I will if it's something I know I can control. So I think I was like, hey, I'm not familiar here. How you doing? I always start off with, good morning or good afternoon. Well, Mr. Such and such, how are you? And so I did all that. I walked him back through, try to lock him into what he just had said. I said, you just testified that, you went to my client's home after the benefit. So you weren't at the benefit. He was like, no. I'm like, you didn't see my client before, see what he was wearing. You didn't know, but you said he was wearing white and black. He was like, well, yeah, but he had to change. I said, but in the home, you said he was wearing white and black. I'm doing this. I'm locking him into this, what he had on. I was like, and at some point you end up at this fire station. And at the fire station, you are in an ambulance. I said, and you told the ambulance people who are in EMS or EMTs, when they asked you his name, you said Gene Harrod, Gene Wilson, Gene Harrod, or Gene Wilson or something. And he said, why would I say that? I would never say that. I know my cousin's name. I said, okay. And you didn't, when talking to the officers at the hospital, you didn't say, when you saw somebody coming down the street that you couldn't see who it was. So you were like, yo, who is that? And he said, no, why would I didn't know? No, I initially, I didn't know. But as soon as he got closer, I knew exactly who it was. That was him. I said, you also said the person was in all black. So I'm walking him through things that have not even came up, right? This is directly from the evidence. So I'm using this because I'm going to impeach him at some point, but I knew I didn't want to impeach him directly with his own statements just like that. I just doubled down. So I said, you never would call him another name because that's your cousin. You testified that. He said, yes. And you're saying that because it's your cousin, you know his name. So I'm doing it multiple times to see if he's going to change his story. He's like, I know my cousin. I would never do that. Okay. So then, because the names are the issue, because he says multiple different names. I said, you're saying that you saw him and you knew he had long dreads. You knew he had this. You remember saying this. Like, I'm just asking him. Everything that I know is in these videos on body worn cam or what he's saying, because in the ID, he automatically said, you'll hear him say, the body worn cam is covered in the ID. For whatever reason, I guess it's on his hip, but you can't see it when he hands him the car. We don't know who has shown him anything. So he's like, that's him. That's Gene Roy. Yeah. He knew exactly now. 3 days later of being sober, having talked to all these other people, he didn't know it before. And he definitively could not see who it was because even during the ID, they said, how do you know it's him? Did you see him? He said, well, it had to be him because that's who I just was beefing with. Right? Like, he never says yes ever before the day we get on the stand. So now you know, but you didn't know. But my goal was not to impeach him through him. I like to impeach through the officer because I like to get the camera in through the officer, right? I didn't want to impeach him directly. I already doubled down. I already knew you didn't. So that is what he does. He basically denies saying anything that I'm saying. So I start painting this narrative of why I'm saying this dog isn't going to hunt because I know what I want to do next.
You essentially allowed him to get on the witness stand and tell a bunch of lies that you knew were contradicted by the evidence, right?
Yes.
So you didn't even have to be mean to them to get what you were trying to accomplish.
Right.
You know, the people in general expect courtroom cross examinations to always be as loud and over the top and expressive as what you see on TV. But in a lot of cases, like this one, you can just be calm and maintain your composure and tie them down to a bunch of things. And it's almost like punching somebody without them ever knowing you hit them, but they wake up the next day with all the bruises from the punches you inflicted.
Yeah, yeah, he didn't even see it coming. I mean, he got frustrated a little bit because I guess everybody assumes if you're practicing that kind of, you must know it. I was like, I know it seems the same, that I'm asking you the same question you just answered, but I'm just need clarity, not from here. So I was trying to throw that I'm not from here. You're kind of helping me. And then he calmed down because at first he started getting a little rowdy. They automatically think we're gonna attack. So I try, but victims, you have to sometimes tread lightly. Any witness, honestly, I try not to be too mean.
I tell people you can only be mean if the jury gives you permission to be mean. And they only
Right,
give you permission if a witness gets on the witness stand and the witness is a complete jerk. And you
right,
see the jury starts to get turned off by that witness.
right.
That's your permission. Now you can be mean. Now you can be
Mhm.
as hard as you need to be. Who's next after the victim? Who do they call?
They called the lead detective.
Do you get the body cams in through the lead detective?
No, I was stopped by objections. And so I am only able to get in this video of my client, the one where he's coming out of the apartment and then he goes back in. Like you see people come out after him, comes back in, and then this one person comes back in all black. And I only got that one portion, right? We had already agreed to not call the person to authenticate it. They allowed it. But then when I tried to get the second half to show that he never comes back out, they objected, and he now is claiming, oh, it's not authenticated. So he pulled this out after I've already gotten a piece, and I was like, I looked at the prosecutor, I was like, oh, this is the game we're about to play because you don't want them to see that he never comes back out this home. So I'm like, okay, I see where this is going. But I couldn't get in the body worn cam after he does the ID where he starts saying it had to have been him. All the statements that are different, other than the one who's on the EMT, I still, that's something I don't get in either. I get in none of these statements that I have just put in front of this jury. I get in not one video because he kept saying objection hearsay, objection hearsay. And it is a newer judge who was the judge there. So that sometimes is problematic on those because I'm arguing. I'm like, this is not that's present sense impression, or this is, I'm giving every exception known to man that could get that in because I'm not saying it's for the truth of the matter. This is what he is saying is his, recollection of something, or this is directly, and it's no longer hearsay because he said it on the stand. I'm allowed to do this for impeachment. If I want to impeach, I should be able to impeach.
Yeah.
But if we're going to go non-impeachment, then I'll give you every hearsay exception that I can do it. And it's not hearsay. So she's like, I mean, we spent so much time at the bench. He objected at every time I asked a question. He said the same thing every time, hearsay. And I'm like, it's not hearsay. I'm arguing every single one. Now, I want you to be very clear. This is why this is significant, because the case that I won, the home invasion, was the same judge. And during that case, I didn't win on anything that was objected to. And I didn't even win a jury instruction that said it shall be given. I still did not get that jury instruction. I still won that home invasion case. And that instruction was important, right? It was definitely an appealable, reversible error. And I believe that all of the ones, had I have not won, would have been ripe for appeal. And that's why he wanted to take it to trial, because he already knew that probably was going to happen. I mean, I couldn't get anything in. It was worse. We spent, to the point where one of the jurors stood up because their knees were hurting. That's how much time we were at the bench for that entire day. And he only called those two witnesses. I did almost a 1 hour cross that I couldn't get through on this detective. He had also opened the door to the lead detective. So I asked a lot of questions on the lead detective that were well beyond his direct, but it didn't matter. He kept talking. So he kept opening doors. And he was like, she's well beyond my scope. She's well beyond the scope of my direct. And she was like, that's the only thing I want. She said, well, that is the lead detective. And he opened himself up to it. So she can ask as long as she wants. So when they said the juror stood up and they were getting antsy or frustrated, I started thinking like, okay, this is about to taint the jury. And now I look back because he's making it seem like I can't do my job. But sometimes you get lucky with a judge. He was lucky to have that judge because I never win anything in front of him. So I'm like, I prepared for this.
Part of your strategy is preparing for the judge.
Right.
What do you get out of the detective with your hands being as tied as they were by the judge, what did you get out of the detective that you thought was helpful to your client's defense?
So I got out of him, I got to get the video in. And I said, and to your knowledge, is that person in the white, shirt with the dress, do they ever come back out? Right. And he was like, to my knowledge, they object. She still let him. That's the one she let him answer. He was like, to my knowledge, no. I said, because you have video that's an hour before and an hour after, right? And he was like, yes. And so I got that. I got in everything that they didn't find. No gun. I got that. The only identification, this was the only suspect that they had because of the identifications. I got that. And I got out that there was no, to his knowledge, no DNA, no video. Like I basically asked him, so you review everything. Everything comes back to you. So I was able to ask, what did he gather in his investigation? And I was basically all the things I said that they wouldn't have, other than the ID, the part about the ID I wanted to get in. He was able to verbally say, yes, it was multiple names, that were given to us. So he verbally was able to say it because of the way I asked it. But anytime I would ask a question that he had to have gotten it from somebody else, now this state is like worried what I'm about to do. So he instantly objects, like, that's hearsay. I'm like, so you're telling me every investigation, if an officer says from this officer told me, we're going to now say it's hearsay. So I got out the things that kind of still said you didn't have anything. Right now, this is literally, we're here because of this victim. We're here because of him. And that's what I got out of him. So
it sounds like you were able to get this detective, even with your hands tied, which is great. You were able him to basically acknowledge the things you told the jury in your opening statement they would not see, right?
Yeah, for the majority part, except the identification. But yeah.
We never score all the points we want to score because of the rules and interference and these things that are beyond our control. But it looks like you were still able to get enough out of this detective to help your client's case. So who do they call next? We have the victim, we have the lead detective. Who do they go to next?
I want to say we went on a break. I tried to argue a motion in limine to exclude the body-worn camera, and talk about it. They simply said it was not premature or something. I don't know. It kind of got denied because I didn't want to do a full hearing with the person they called, which is the detective who does the identification. And I didn't want to call him prior to him getting on the stand because I didn't want him to know how to switch it up, right? Because our body-worn camera was completely covered. So it wasn't covered until all of a sudden when you're getting ready to ask the questions, now it's covered. So I was like, something's off. I'm going to challenge it. But I ended up not even challenging that because they knew it was coming. And so he had basically told him. And so he said, I wear my body-worn cam on my hip. And another officer had kind of confirmed that to me in the break. So he was like, it's new to them that the detectives are now wearing it, but they don't wear a regular uniform. So it's on their hip. So it might have gotten covered like if he was sitting there. It probably wasn't. And I had seen this same detective in another case, the same thing happened. So I kind of already thought it wasn't like purposeful, but it didn't matter. It's about my client at this point, right? But I ended up not challenging that. So they call him, they got in that the guy definitively says, yeah, that's him. But that's word of mouth, right? But I'm already painting this picture that y'all kind of being evasive. Y'all don't really want to answer my questions because the lead detective was already a little snarky. He didn't really want to answer because he knew he had to answer. So he would say, well, that's not all we had. And, he slipped up and also mentioned that the witness, Ronnie Chase, which is the one who's inside the home. Now, we had never heard that before. Allegedly, now this person who was in the home is now an eyewitness to the actual shooting. But they don't call this witness. He never gets called. So that was a gold mine for me because you got an eyewitness and you never even question him. We don't have no video of that. I said, you never interviewed him, right? Well, he never would show up. Right. Like, so that happened. Then the ID gets on there. So I don't attack the ID person because I'm like, it's not that big of a point. This is not a proof of collusion or y'all doing something. It would have mattered if I would have got the evidence excluded. So I'm not going to attack you here. So they call him. That was quick, but they at least got that in. So that was something I was kind of a little worried. Like, okay, if they believe this story, he's definitively just the victim just said it was him. He was certain. He says, then you got this guy come on the stand saying, yeah, he definitively within seconds said that's him. So we now have this double down of an ID. So that was the only worry that I was like, okay, I might have to overcome that in the back end some kind of way.
Were you able to take on that officer or not really?
I played it cool with him. I didn't even address the attacking of the body-worn cam because I still was confident that I still had one more officer that I could impeach. I had two more officers that I could impeach him through if allowed to get it in a different way.
So who's next? I know we still have to talk about the crime lab tech.
I think that's it. I mean, they called multiple people, but the main ones they called, the crime lab tech was the next one. That was a win for me.
Take us through the crime lab tech.
He was being very dramatic. He took the casings and the shells, and he separately like packaged them. And so he had like 20 exhibits, or like it was 20 exhibits, but he would call it like 16A, 16B, 17A, 17B, like all these things. He has all these bullets. So he walks her through on direct, and you were there, you took photos and you picked up this, and he puts in all these pictures of the blood on the, bullet and all these different things. And the whole time I have my head down. So I'm listening, but I'm just head down, writing down. And so they would say, any objection, and I would look up or not look up, no objection to every single piece. I never blinked, never moved. I was like, no objection, no objection, no objection. Let him get it all. And he does this for about 45 minutes. This is how long this goes on and on. He's so dramatic. And so then I go on, cross, and I said, when you arrive at a crime scene and you find shells or casings, you don't know how long they've been there. She was like, no. I say they could have been the day before, 2 days before, because you hadn't been there, I don't know, day before that. I just go through it, and she was like, no. I said, and the blood, because they brought out the fact that if there's blood on a bullet, you can't get the DNA or the blood. You can't match. They don't test that because it's always inconclusive. That was their thing. He tried to hurry up and get out there that basically no DNA came back, right? No DNA came back. But what they're not realizing is, we're talking about the alleged blood of the victim is on a bullet, and there's alleged blood of the victim on this pole that he's allegedly shot at. And so she does swab that blood. And he mentioned that she sends it off. So I said, you swab the blood. I know you said you couldn't get the blood off the bullet. So I walk her back through why you can't get the blood off the bullet. And I said, you don't know if the blood was on that bullet weeks ago, you don't know, right? So I go down this, you don't know how long this has been here. You don't know if this is from this crime scene. In fact, you don't even know if Mr. Creek had been, which is the victim's last name, if he had been shot from down the street and ran up here. We don't even know if he actually got shot here. That's literally where I ask her all these things, because I walk her through each bullet. Like each piece you heard. So basically to say, you got all this in, you don't even know where it came from. She's like, no. Then I said, well, what about the blood on the pole? You swabbed that blood. Said, yes. I said, you test the blood? She was like, no. And then I said, so you don't know if that's even the victim's blood? No, because we know it's not my client's blood, right? Like, I'm like, it's not that. You have no fingerprints, no nothing. She was like, no. So it was crucial for me to really attack that. But he thought he was being grand by saying all these casings are matching up to the amount of times that Mr. Creek said. But there's never any video introduced on the scene. They have video from the scene. They have video from the time of the incident. They have a video that even shows the pole where he allegedly got shot at. And there's no video of this shooting or him even at the pole. So, but they don't get all this. None of this gets put in because they don't even call that guy. Now, I subpoenaed every officer because I've learned they only call who they want for their case. They don't call every officer. There's 15 officers here. You only call 4. They very much are asking very quick questions to the lead detective. He didn't ask the lead detective much. So that's why he was shocked that my questioning went so long, because he tried to narrow his direct. Same thing with her. She was the gold mine for me because I basically had proven to them, I told you guys they don't have it. And so that was pretty much the last of theirs. They had nothing more. They called nobody from the search. He called nobody from, no other officers that actually were at the scene. He didn't call anybody who could basically had heard him say multiple names. They didn't call the officer did the first ID when he was in the ambulance because they didn't need all these different statements to come out.
And then they call your client's brother.
Yeah, they call his brother. And his brother, they wanted to get out of him that there was an argument, that they were around each other. I guess because the locations are close. When I say close, I'm saying literally you can leave this apartment and walk to the CVS where it's allegedly happened. The EMT place is literally, fire squad is like right around the corner. So it's very close proximity. So they were trying to lock in. They essentially served his brother with a subpoena, to come to court to testify because our case was supposed to go 2 weeks earlier. And at that time, that's the first time they ever interviewed his brother. And his brother tells them this whole spiel or story of how, his brother and him, they got into it, but then the boy left. No violence happened. He says, whatever. So they call him just to, I guess, corroborate that they were actually at the home that's right around the proximity. So he gets up there. He was like, yeah, but he don't say everything he had said during the video. Of course, they don't want to play the video. It's duplicitous. He's on the stand. And so he's like, that's our cousin. I didn't like that he said that. My client's like, that ain't our cousin, but whatever. So I'm letting this guy come out. I said, one of the things that I had asked the victim was, you said your cousins and you know all of his brothers, and you said they all have dread. And he said, yes, they do. They all have dreads. They do. And I said, okay. His brother comes. He has no dreads. He didn't have dreads that day. He doesn't have dreads. So were you high? Like, and these are the questions that I'm thinking in my head. Were you high? Were you really there? Do you really know these people? Like you say, you know your cousins. I was like, have you ever had dreads? The brother says, yes, this is me on cross. And then I said, you had dreads last year? He was like, no. You had dreads before that? He was like, no, it was some years ago. I haven't had dreads in years. So I'm like, okay. So I got out of him that he never had dreads, that there was an argument like, and it didn't get physical. To the best of his knowledge, he went back to sleep. Now, I also was glad that he said he went back to sleep, because if I needed to paint him as a liar, because I knew he had actually left out. There's video that shows him actually near the scene, like in all black, in the outfit that matches what he said he saw, right? So I'm like, I'm giving this illusion of whoever y'all want to believe, I don't know, but I know that his brother had on all black. And I asked him, what you have on that night? He said all black. The victim said he had on all black. So I'm painting this narrative. Okay, when we get to this all black, maybe I might have to say something. But you have to realize the officer who I got the video in of where my client goes in and out, he could not say that was my client, because he can't identify my client from that video. There's no clear face of this person. So nobody is able to ID it. He's just able to say the person in the white and black goes out and comes back in. So I let that be whatever that's going to be, because I didn't know if I was going to be able to get anything in if I have to do my case. At this point, after they called the brother, I think he might have been the last person they called or something like that. It might have been the crime scene tech. But whoever they called, their case ended on day 2 at the top of the day very early. So they rest their case without any of my videos getting in at that point.
Did you call any witnesses?
I did. I tried not to put on as much of a case if I don't have to, but in this situation, when I got locked up trying to impeach, I figured, okay, I could do it on direct. I called the officer who got the first ID with the EMT. And so where he's saying, oh, it's Jean Harrod, Jean Wilson, all these different names. I started asking her questions, and I said, officer such and such, where were you on this day? You know, now I'm going on, it's hard because I'm a direct. I gotta ask these open-ended direct questions. It's hard. So I'm like, where were you on this day? She goes to the school, we get there. And I said, was there ever a point that you encountered the victim? And she says, yes. And then I said, where were you? She says it was in the back of the ambulance. He was there. And said, were you able to have a conversation with him? He's like, yes. And then I was like, and were you able to ascertain a suspect? And she said, not at that time, which was good because she had asked him. I said, you asked him who was the suspect? She said, yes. I said, were you able to ascertain? She said, not at that time. So that was literally probably the only thing I was able to get out of her, because as I moved forward and I tried to basically bring in the body worn cam, again, he objects and was like, it's hearsay. I was like, it's for the purposes of impeachment. And so we go through this argument on impeachment. She was like, no, you can't impeach like that. And I was like, why can't I impeach? He doubled down. She's like, why didn't you show him the video first? So I didn't have to. He definitively said, I would have never said any other name but that guy's name because he's my cousin. He said that 3 times during his direct. It's out of court statement, not here to prove the truth. If you want to do it non-impeachment and we want to go to hearsay, right? You want me to argue down? That's present sense impression. She was there within minutes of it. That's present sense, excited utterance. He said, am I going to die on this video? Like all these things I had asked, all of this can come in. He's already testified. You know, I go through my argument and we're up there again. It was the most horrible experience to look at my client come back to him 3 times and keep coming back over there saying they're not going to let us get this in.
So even on direct, the judge still doesn't let you get it in.
Doesn't let me get it in at all. And I was just floored because I'm like, I remember this feeling all too well. And my client was so calm. And I was just like, we're not gonna be able to get this video in.
Well, you were floored because that's like basic evidence 101, right? That stuff is supposed to come in. There's specific present sense impression is in the code of evidence, which basically designates a statement as non-hearsay or an exception to the hearsay rule because of how the statement happened. And the judge definitely knows that.
I mean, that was basic, you know, that one, then existing state of mind, like those ones are like your go-to quicker ones if you really have to go. I even went so far to say, well, this is in the course of business when we're talking about an officer, in the course of the investigation, you can even go that route and there's no wrong way to kind of get that in. They know this should come in. I've never had a problem getting it in other courtrooms. Don't know why I'm having a problem today. You know, they forced me to even bring this up on direct. So now it is my case and I do get to put it on and I couldn't. I knew they were going to object, but I still went on and tried to do it with the report that she had wrote. But the point is that at this point, I'm showing the jury in my mind, this is all I have left is they don't want you to see something. I've asked the question 16 different ways. They have objected. We've been to this bench 16 times. Something they don't want you to see. You're going to have to linger on why, right? You can't stop them from knowing why this happened. So at some point I'm like, all right, and they can see the clear frustration that I'm having. I'm like doing like, and I do dramatic gestures on purpose when I want to show them like, it's not me, or I'll laugh. I'll stop and be like, I don't even know what y'all want from me. Like, I'll do that kind of stuff. And so I leaned over my client. I was like, I don't know. So I let this witness go. And then she said, you have any other witnesses? And I was going to put on more officers, the other officer who was in the room to do the interview with him about the other thing. But I already knew we were going to run into the same thing. I didn't want to frustrate the jury. So this is only day 2. So I was like, I would like us to go ahead and go to lunch. I need to discuss with my client if he's going to testify. And that was not planned. He was not supposed to get on the stand. I didn't need him on the stand to win this case, but I had looked at him. I said, you're the last hope. They have to hear from you. And he was just like, what do you want me to do? And I was like, all right, we're going to do it. We go on lunch and we talk about him telling, his truth about his past, because, they can attack you of your past once you open the door. So we decided we were going to open that door first and we were going to address it. They can only attack you if you lie. They can only attack you if you haven't brought it out. But once it's out, they can only just stay within it. And it doesn't work out for everybody because they don't anticipate us wanting to talk about it, because my client has a literal violent crime, stab someone, right? So now I have to figure out how we're going to master getting this out here. And I'm not going to lie, some of the stuff my clients don't understand, I was like, oh. And I had to navigate in real time. And he said it was behind a dog or something. I don't think I remember that fact. So I was like, a dog. Okay. And so I'm like trying to navigate his story. But ultimately, he gets on the stand, he tells them that he was, in fact, engaging in the activity of selling because he had a felony, couldn't get a job or whatever, blah, blah, blah. He was like, I asked him, why did he stab the person before? He's like, I was scared. He kept following me. So I was showing him how it's different, right? Like, were you afraid of this victim? And he was like, no. And I said, why were you not afraid? He was like, he was hired up. And I said, what is hired up for the jury? Can you explain it? He said he was high. He was a joke to me at that point. So I had no reason, like, to go after him. I have no reason to attack him when he's high. Like, look at him. Like, what am I do? I'm not scared of him. I was scared of the dude I was walking my dog, and this dude kept coming. I told him to back up. He wouldn't. He kept getting closer. I turned around and I stabbed him. That was his story, right? Like, that's why he went to prison. And he was like, I'm back home. I've only been home for a few months. I'm not looking for no trouble. I'm doing what I can to get by. Just buried my mom, had to pay for that. That's why I was doing what I was doing. So he gives his narrative. The state gets up, cross-examines him. We have much cross now because I've already pulled everything out. And they're like, oh, so you would say you stab people, but you don't shoot people, like all these different things. He was painting this picture like, yeah, my client was like, nah, my client leaned back. He's acting like himself. I told him, be himself. Don't change up for nobody. Be yourself. Like, don't try and fake this whole like, oh, I'm so great. No, I have a past, I have a history, but that's not why we're here today. And I asked him, was that guy your cousin? He's like, no, he's cool with my brother. He's older than me. They're older than me. They're really close friends. I didn't even grow up around here. I've been in prison all this time. So he's clearing up the story. I said, why would your brother say that? Oh, well, he's like, because my brother and him are close. Like, they're cool. You know what I mean? Which made his brother even still kind of credible, because now his brother's saying there was no violence in the home, but that is his cousin. So that's how he's tying this gap. And then I asked him, your brother, do they have dreads? He was like, my oldest brother does, short ones. I'm no longer, but my middle brother, as y'all saw on the thing, no. It was another statement made by the victim on the video that my client was bigger than his brother. So they had just seen his brother. His brother was way bigger than him. His statements was, I knew it was him because he was heavier than his brother. Like he said, my client was. So I was letting this be things that I had thrown out there. And now you see that he's bigger. So I was kind of tying every loose end that I could through my client. And then I put on the video of the apartments that show my client come down and go back in. So the important thing about that was I asked him in the video, I said, who is this? And he said, that's me. Identifies himself, the white shirt, long dreads. I said, and who was that person that came out? He was like, that's my Uncle Chase. And who is that? That's Joe. Right? Like, that's my brother. So now we know Joe did leave the home. Joe didn't go back to sleep. Joe came out the house and Joe had on all black. I said, what does he have on? He has on all black. What do you have on? White and blah, blah, blah. So now I'm separating the two to say there was a person who came out on black. And then we go back. He goes back up. And then I said, is that you leaving back out in black? Or he's like, it could have been my brother, because when I came back, my brother wasn't here. Because he comes back first. His brother and them come back after him. So when I asked him, where was your brother when you came back from going off? Because he said he goes off, he makes a drug deal with somebody. They drop him back off because you're going to see a car drop him off. He gets out, he goes back in. Was your brother there? He goes, no. my brother wasn't there, because his brother wasn't. Then on the video, you see the uncle come back and you see his brother come back. You never see my client come back out, and then you see a person in black come back out. I never make him identify who that person is in the black. I just simply left it being what it was. And then we cut the video off. He going through, the state then doubles down. You said your brother wasn't there. Like, this is all they're asking. I come back on the rebuttal and I said, you're saying your brother wasn't there because when you came back, he wasn't physically in the thing based on the video. He's like, yes. And so I just kind of double down on all the things that they do. And then I rest the case, because we tried to do an MJOA, or a motion for judgment of acquittal, in between the cases. I'm obviously denied, which I already knew.
You couldn't win an objection. You knew damn well this judge wasn't giving you an acquittal.
Then we renew it after I rest. Boom, I already knew wasn't going to fly. And so we take a break. And then at this point, we go back and we all talk about jury instructions. We go over these jury instructions, and we have to agree on what jury instructions are going to be used. He realized that because he didn't indict the case, that they did not indict anything about a knife, and they didn't indict anything about anything that happened at the residence. So he was trying to leave it vague, and he had started non-prosing some of the gun charges. So I knew they weren't coming for the jury, but he was trying to basically allow the jury to decide whether the assault was for the knife or whether it was for the gun. And I looked at the indictment and I said, Your Honor, the state has no more room to change the indictment. The indictment was locked once they rested their case, and the indictment says the scene of the CVS. So anything that happened at the home is irrelevant to me, and I don't want to hear anything about it in closing. They can talk about it if they want to, but I want it to be read out that they have to make a decision on this, because on the verdict sheet it says a spill, and on the spill I made sure it had the address of the CVS so they know it is pertaining to that only. We're not here for a stab. We're here for what happened at the CVS at that time. Did they have it or not? And so he was frustrated at that point, because that's the only thing that she had to say. There's no way I can get around this. I know I'm going to lock him in here. We do all that, and that happens. Jury instructions, we review that before we even go into closings. You don't go into closings yet. Reviewing them, come back, they went to lunch, come back. We've done it, and then we go into closings. And then once we get there, this is when everything just gets spells left,
So we're in closing argument, right? The prosecution goes first, then you get to go second, and then do they get to do a rebuttal closing?
They do.
All right, let's start with the prosecutor's closing. Take us through that.
I'm assuming that he was caught off guard by the questioning that I did during direct, or that happened with my client being on the stand. Okay, so he starts off by saying, ladies and gentlemen of the jury, I told you this case would be 2 days. I still thought it would be over in 1, really, but there were delays, not of my fault. That's what he said. So that's shots fired, of course, at me, I'm assuming, trying to say, I couldn't ask questions. I don't know how to get evidence in. Just trying to play on the jury to say, she's unskilled. That's not my problem. And so he leans heavy on my client being a drug dealer, and my client being a drug dealer who's been to prison, who's violent, and that, he's going to try and tell you that he's a stabber, not a gunsman. I didn't get those other statements in of what the victim says. So he's like, the victim has ID'd him here in court. He ID'd him at the hospital. Definitively, he said it was him. It's him. He says that, that he's the one who brings out the fact that the victim said he was going to come back and shoot up the house. So he leans in on this. He had motive. He was hurt. Guy says he's coming back. He was like, I can't let this happen. This is all what the state is saying. It's in his nature. He's a violent individual. If he doesn't like something, he just does whatever it takes. And it was him. He just do all this. That's the state's entire thing. But first they start off, of course, by letting the jury know, of course, that they don't think I was skilled, that, I'm the reason why they're still here, basically trying to taint their mind and place blame. They're talking about the proximity, and, he just trying to basically say that she's no good. She's trying to bring something in and he's no good. That was the picture he painted. This is just don't believe anything they say. They don't know what they're doing anyway. And they're just saying anything to survive. That's pretty much was his original closing.
When you say original closing, that's because he took it even further in his rebuttal closing, right?
He did.
But I don't want to go there first. Take us through your closing argument, and then we'll get to what this guy did in his rebuttal closing and how it blew up in his face. But take us through your closing.
So I'll first start by saying, every time I come up with a theme, I will make a closing, but I've never have used my closings that I write. Never. While he was talking, I essentially told my client, like, I didn't get half of this evidence in. How am I going to come behind him saying all this stuff that he has definitively said? I made all these cliffhangers and I don't know if I've closed it out. So how am I going to tell them this? And I said, that dog ain't gonna hunt. So I basically wing it and I get up there and I said, well, we're going to be the truth tellers and I'm going to keep it a buck. So I said, well, ladies and gentlemen of the jury, I told you guys that dog ain't gonna hunt. Well, I guess it hunted a little bit. It did hunt a little bit. And I said, because the state put on a case that painted their narrative and it made the illusion that it hunted. But the dog still didn't hunt. And so then I went on to say, I went down each person's testimony of what they heard that was crucial. Right? You're hearing a person who says he wouldn't know not who his family is, but you heard the detective say they didn't have a definitive ID and they only had one suspect in the end, but originally the first officer didn't get a conclusive ID. So somewhere down the line, my client is now the person who did it. And one thing I forgot, in the first closing, he gets in this, that it's a document that says from the EMTs that says that they didn't see any signs of drugs or something in his system, in the victim system. And so I said, he brought up this, medical record that said that he wasn't high or that nothing was in his system. I said, A, they're not medical doctors. Let's start there. But B, he was shot in his penis and his finger is shot off. Trauma is a crazy thing that'll wake you up. Trauma will absolutely have you more alert when you're aware that something has happened to you. So we don't know what the body will do. So he could have been very well acting normal. I said, but on top of that, in the South, we have what I like to call functioning addicts. And he could very well be a very functioning addict. My client knew that he was high because he had sold them and because everyone around him does drugs. But somebody who doesn't know what a functioning addict look like might not know that he's actually has drugs in his system. So I was like, I let that be like a really quick thing I spoke on. Then I nailed down the fact about how you saw my client go out. He ID'd himself. He's the only one who could actually ID himself from that video. He told you who everyone is in the video, and he showed you. And what you saw in that video was that he went out and came back in. He told you he went to do a drug deal. That tracks. So I started going down this what tracks, because what I'm saying, did the dog track it down? Get to the end. So I said that tracks. He said that my client did a drug deal. That tracks. My client told you that. Now my client is the one who's told you everything. My client told you he sold drugs. He told you where he was. He told you why he came back. He went to the scene. He told you how he knows this person. He told you who was in the video. I go all the way through that. And I said, the state has not disproven anything, even though we have nothing to prove. The state can't even disprove me telling you that he never came out because they didn't even allow you to see that. I just kept saying the state put on a narrative that is representative of the case they want you to see. This is not piecework. They can't piecemeal evidence. It's not patchwork. It's not guesswork. You can't go on a hunch. You can't think somebody did it. And we have a very shaky victim who still to this day is saying that his brother had drugs, and you saw his brother. Till this day saying his brother is smaller than my client. You saw his brother. Like, he clearly has not given up drugs. He's clearly exactly what I said he was. And so, I go down this whole spiel. I said, Mr. State, because I always say like Mr. State or Mrs. State. It has told you that my client is a stabber and that he's violent. I said, well, he did stab somebody. He did do that. I said, and all of his crimes deal with knives. And we don't have a knife in this one. So that tracks. He's not a gunsman. I just went on with that. But also I said, ultimately, my client got on that stand knowing that the state could attack him on his past, knowing that he had committed what is a violent crime. And now they're alleging that he did another violent crime when he came back after doing 6 years. He admitted to you that he's still doing things that are illegal, but that's survival. I said, but you want to know what he's really admitted to y'all, and what he told you is that was in his past. We're talking about November 9th, 2024, and they're saying that my client committed attempted murder, a charge that carries a weight of a lifetime. They're telling you that he had to have been doing this because of his past. We are not here for his past, and if we all were held accountable to our past, most of us would not be where we are today. I said, and he is here fighting for his life when he shouldn't even have to. He lost his mom. He had all these things going for him. He was trying to get on the right path, and we're going to talk about his past. I won't spend time there. But he got on the stand. He told y'all the truth. He could go to jail for selling drugs, but he told y'all the truth because it has nothing to do with whether or not he did this to this person. And the state has not given you not one piece of evidence that would do it. I said they let all those bullets in. I let every piece of evidence. At some points, I wasn't even looking up and I was allowing it. Why? Because it means nothing. They did a lot of nothing, and they showed y'all a lot of nothing. So if anything, these 2 days that we were here, that were stretched out longer. I said, there were things that the state just didn't want you to see. And unfortunately, that's the nature of the game. I said, but I'm going to tell you now, the dog didn't hunt. And don't let an illusion and don't let piecework and don't let half evidence and half conclusions from one side that they really can't back it up be the reason why you find my client guilty. And I like did that or whatever, and I rested. And then he goes, then it's time for his rebuttal. But I kept it as light as possible and not attacking him and making it personal, but saying the state, this is a catch-all thing that people do as defense attorneys. When we know we kind of had our arms tied behind our backs halfway through, I couldn't even say the dog didn't hunt definitively, but I had to lean in because that was it. So I can only go for piecing together the evidence that they actually have and piecing together the things that you don't, or things that are really smoke and mirrors. And so that's what I spent my time doing, was basically the evidence.
So now we get to, after you do your closing, this is probably the defense attorney is most nervous because that is the last time the jury will hear from you.
Mm-hmm.
And you kind of get sandwiched in between the prosecutor's original closing argument and his rebuttal close. So now you've given your close. Take us through his rebuttal close and be sure to point out the comments he made that were essentially thrown back in his face by the jury.
Yeah, so he started off by reminding the jury that, he respects every attorney he goes up against. And he's always had a great amount of respect for them. And he's a former defense attorney. And as a state's attorney, he takes an oath. And that oath, he takes that, I guess, with pride, and that it is to uphold justice and ensure that justice prevails. And he's here for justice. That's what he said. And he said, and he has always respected defense attorneys, and he knows they have to do a job. But if the defense, ask a bad question, then I'm going to object. And he said, and the state is hiding something. The state's not hiding anything. You have everything we have. Just kept saying it over. We're not hiding anything. We're not hiding anything. And he said, if the defense can't ask a question, if they don't know how to ask questions, then they should go back to law school.
Whoa.
And, yeah.
This man told the jury, you should go back to law school.
Mm-hmm.
How did the jury receive that?
You could see them kind of like shifting their seats. Their eyes kind of got big. The courtroom themselves was packed. So you can hear a lot of, like gasping, stuff like that. Literally my face was this. And I just sat there because I know the jury didn't like that. You could feel it in the courtroom at that point that it was going bad for him. But he was angry. He was yelling this, by the way. Right after that, because his rebuttal was only maybe 2 minutes, but it was literally just about me the whole time. Then he said, oh, he's not a stabber. They're saying he's a stabber, not a gunsman. He went to prison for first degree assault. I wonder what else he's gotten away with or something like that. And I objected at that moment to that. But simply, I was objecting at that moment because my client didn't go to jail for first degree assault. He went to jail for attempted first degree assault. And I'm like, I'm going to let the record be clear that that's a non-fact. And I don't object during closing because we all know like objections and closing are almost like unheard of. But I was like, okay, I'm going to do it because I know I didn't object during a closing in another case. And to me, that was a crucial point that messed up my client's, case, the only other case that I've lost. So it's 2 cases I've lost out of 7 in the past 2 years. And both of them, it was like little things. I was like, I wish I would have done this, differently. That's how he ended it after I object. Like he was like, he just sat down and he was like huffing and puffing. It was like very dramatic. He was very upset. Visibly, you could see how upset he was. He was pointing, he was yelling this out. And I was like, I didn't do any of that. I don't even know the jury, I think, caught on to the fact that he kept saying the word hide. And I never once said that the state is hiding.
He introduced that word.
He introduced the word hide. And I was like, I never said hide. Because I went back and listened to my close and I was like, did I say hide? Like, why was he so ticked off? Like, what happened? What did I say? I thought it was just pretty generic, game on stuff, nothing crazy. I just kept saying the state is putting on a case that fits their narrative. I said it like 3 times. The state put on a case that fits their narrative. Because, of course, like I said, my hands were tied during a lot of things, so I left a lot of cliffhangers. And so he says, the state's not hiding anything. We're not hiding anything. He said it like 4 times. And I was like, why would you say that? So then he's like, you have what we have. I'm like, you don't have what you have. If they had, but he meant me, like you as a defense have what I have. You have everything we have. So this is nothing new. And he said, if you don't know how to ask a question, that's when he went into the go back to law school spiel. And I was just like, you introduced all of this in front of a jury. The jury expects the state to be perfect. They expect the state to hold professionalism at all times because you represent the community. So when you do something like that, that does not sit well for them. And I felt like that people thought it was racist. And I say that because I'm Black, my client's Black. He's talking to basically an all white jury except one person. Judge is white, he's white. Everybody in the courtroom is white, right? Like, and so now people don't want to be a part of something that is somebody else's problem. Like if let's just say he was racist, and I'm not claiming that. I don't know why he said it. I don't know what triggered him, but it made the state look like they support that level of behavior. That's an extension of the state, and that is embarrassing for the state. It's bordering unethical, and I think it is. I think in our oath, we're not supposed to disparage other attorneys. It's literally something you're not supposed to do. And he did it anyway. And it says a lot. It speaks volumes because it made everybody uncomfortable. There were state's attorneys in the room. They were just like, everybody was in shock and like waiting to see my reaction. But I knew if I react, then I'm going to be the typical person that they think I should be. So I just sat there.
So after he finishes, you guys ultimately get to the most anxiety-filled part of the trial. That's waiting on the jury verdict as the jury is deliberating. So as they are out deliberating or deciding the case, that's what deliberating means. Tell me about your client. How does he look? Does he say anything to kind of give you an insight as to how he's feeling? And what are your emotions during that time?
First time we talked was right before closing because I went back to the back because he's being held. When you're held, the jury doesn't know that they're incarcerated because this all happens outside of them. So I go talk to him and I was like, I don't know, man. We got to do what we got to do. He was like, Ms. Drummond, you're not busy looking at them, but I'm watching them, and I don't think it's you that is frustrating them every time they have to stop. He said, I got a good feeling. Like, he's a believer in God. He's like, God got us. We good. I'm like, okay. So then after closings, I briefly spoke to him right there in the courtroom, and he was like, I think we good. I'm really not worried. And I was just like, I don't know what you just saw. Like, I'm a little worried. And he's like, no, I'm good. God got us. I'm good. He was like, go, whatever. You can come back when they're going to call me. So he goes back in holding. I don't even go visit him during this deliberation. I go outside. I'm in the courtroom still. So I stay in the courtroom because a lot of the bailiffs, they're really nice. They're cool. One of the officers who I was going to call up there was in the room because he knew I wasn't calling him anymore. So he was watching. And they instantly start asking me, like, how are you feeling? Like, that was real crazy. Like, I can't believe he did that. And I was just like, I was upset in the moment because I was just like, I didn't expect to be attacked like that, but I didn't know what was going on. But everybody else was kind of like just talking to me and laughing about things, asking me about like my remarkable pad that I have. So for the first time, I didn't even end up leaving by the time the jury verdict came back, I hadn't even left the building. Or I hadn't even been out of the courtroom. I typically don't leave because at that time it was like when they went to deliberate, it was like 3:00, 3:30 or something like that. And so I was still in the courtroom. I was just laughing, talking with people, trying to be calm because I was like, it can go either way, but really holding my nerves back because I know it's a very serious case. This would be my second attempted murder. The first one I had lost like 2 weeks earlier. And I was crying because my client definitely didn't do it, but accomplice liability got him a conviction. So we're still, of course, trying to fight that at sentencing for years, but he didn't do it. And there was actual video of this incident, right? And I'm watching him get convicted of it. I'm like, if they've seen it, you don't have no evidence. So my mind is just like, I didn't get anything in. Like, I'm just beating myself up the whole time. Like, this is going to go bad. And this is a case that I know I should win. I don't know, but I should be winning this case. My client just calm. I'm the one that's like panicking. So I'm trying to talk and laugh the whole time. And so then, of course, they call our phones if there's a note or, if they have a verdict. So they call our phone. I'm like, oh, they must have a note. Literally at this point, been 50 minutes.
Oh, wow. That is
only not even an hour. We get this call like, hey, and they're like, oh, it's a verdict. And I was like, what? I'm like, well, I'm already in the courtroom.
And look, before we go to a verdict in under an hour is typically bad for the defendant.
Oh my gosh. So instantly my heart drops.
Most times jury deliberations last hours, sometimes days. And the quicker they are, the quicker I feel like it's not going well for the defendant. So you get a verdict in under an hour. Y'all go back in. What is your client's reaction and your reaction when the verdict is read?
So right before, he's still extremely like, I'm good. God got us. He's literally keeps saying this. My head's down. So as they're about to read the verdict, you hear it. I have my head down. Me and him are standing. And then they were like, on the account of, how do you find, Eugene Terrell Harris, on the account of attempted first degree murder? And they were like, not guilty. I'm looking like, what is going on? So I'm like, eyes big. I was trying to look at my client. He over there hitting me like, all right. I'm like, calm down, stay. They hit the next one. It's like, if you can't get them on attempted first, you have to go straight to attempted two. And then they were like, not guilty. And then so it skips and goes to first degree assault, because that's like with the weapon. They were like, not guilty. So then it goes to assault too, like not guilty. So it just kept going. And I'm like, sometimes you get these ones where you'll win everything, but this little minor, small piece. So once they got to the reckless endangerment, when they said not guilty, that meant all the rest were gun charges. So it's done. So he doesn't even have to hear those. They don't have to like do those. So instantly after, he's like tapping me, like I told you, like we dab each other up like that. And he was like, like whatever. And then he looked over, he was like, look at him. He read. And I'm like, I'm not looking at the state at all. Because at this point, I'm like, I don't want to give you any rise. We still got to wait till, whatever is over. But my client was ultimately like, I told you, you didn't do anything. I think you were, overthinking it, but I felt confident about it. I'm like, I've never had any verdict came back. The ones that came back fast. Because I told him when it came back, like, I was like, I leaned over and I was like, appeals they happen. Like, I'm instantly thinking, appeal this, it was a lot of things we can appeal on this case. Like, don't worry if it goes south. I'm just a little nervous, whatever. And he was like, I don't think we're going to go that far. He just was so confident. So I was just like, all right. And so he's like, I told you. It was definitely a good moment for me, because I'm like, the audacity of somebody to just, I don't know how he felt, but, I wouldn't even be able to show my face if I had talked that much trash. And then in 50 minutes, they said not guilty on down. And that's for the first time. So that's his first case there. And this is the first time in years that it's happened. So I know for a fact they weren't expecting me to win that case, because they went all homicide. But it showed me that obviously what I'm doing is something different, because some of the ones that I deemed to be good defense attorneys have been down there and could not win homicide cases in this county. So
what happened with that prosecutor, the one that recommended you go back to law school in his closing?
So the next day, of course, I go back up there to go get the recording, because I was like, you know what? I'm going to get it. I'm probably going to post that piece on, social media to show, like, for my client's sake, because we didn't get to get a picture because he had to go back. So the next day I go back and grab the recording and I see him. He doesn't say a word to me, but he's dressed in regular clothes. But he was supposed to be, of course, transferring in like 2 weeks from that. But he was supposed to finish out cases. So I was told eventually by one of the state's attorneys, because they came there, kind of apologized on his behalf, said that's not, representation of this county or of the state's attorney's office. And because it had went into what's called the Baynet, which is a local newspaper. So after my first win down there, I wrote the newspaper, said, do y'all ever post defense stories? Do y'all ever correct stories? Like, my client deserves his story, and y'all plastered his face all across the news, because everybody's face is always plastered. Everything about them, people comment. This is a very highly read thing here in Maryland. And so they were like, sure. So when that one posted, that was the first one. So I think that nobody knew that would happen. So it gave defense people like, okay, when you start telling our stories and restoring these people's names, like I said, I'm here for restorative justice. And so then I had, right before this case, the week before, I won one in another county, a felon child abuse case. We asked for that to be in there, and this one. So the news story comes out, and they mentioned in the news story that he was criticized for telling the defense attorney to go back to law school. So I believe it was told to me that he was benched. Basically, he did not have to finish out his 2 weeks. They took all his cases and distributed them to other state's attorney's office, ASAs, and he no longer had to do anything. Because when they asked him about it, he basically acted like it was no big deal what he had done, and he was not accountable for his actions. And so he was basically let go early.
Well, that's good. What did the case teach you? Every case we learned something as the lawyers. What did you learn or take away from this case?
I learned, honestly, that sometimes really trusting the word of your client, like their decisions and their ask matter. Because in fact, the video of him coming in and out of the home, I'd had no intentions of introducing that at first. But I guess, I don't know if he just felt it, but he was like, we need to get at least that in, just a portion showing that. And I was like, all right, let's do it. So I leaned in, I got that video in, I was glad for it. So I've learned that sometimes us lawyers do think we always know the path forward, but if you really do keep your client engaged in the process, that sometimes they can help you, because they're watching more than we see. When you enter that well, we go into a zone. Sometimes we're tunnel vision locked in, but I'm only going based on what I have, prepared. But also just being able to move and shift when things happen. And I also learned that to start giving myself pats on the back when I think about how my strategies work. I'm one of the only attorneys who will put my client on the stand, even if they have a felony back or something bad, and I will allow them to put that out there. It has worked for me in some cases. Well, really, every case I've ever put my client on the stand has pretty much worked.
Yesterday, I interviewed a lawyer, Edward Johnson. I'm actually going to link your video and his to each other. But he tried a homicide case. Actually, this is what he said. He says, I keep my clients involved. I believe in a lot of cases they should testify. But more importantly, he says, my client, if he acted in self-defense or he didn't do it, he's going to know those facts better than anybody else. Mm-hmm. So if I can prepare him to testify, that's what I'm going to do. And I kind of agree with that.
Right. Because they're the final piece of the puzzle. There was a friend of mine, a colleague of mine, who she tried a case. And, you always ask the jury if the defendant has the absolute right to be silent. They do not have to testify. You make sure that you pick a jury that understands that well. And they had a hung jury. And the jury said the problem was the guy kept saying, why didn't we hear from the defense? I need to hear from the defendant. I need to hear something. And so I always tell people, sometimes your voice is missing and you're the only person who could tell those facts the best. You're going to be yourself. And I always tell them, do not try and be polished. If you curse, curse. If you were angry in the moment, be angry. Do it exactly in real time how things happen, because people have to see I was there. If you say I'm there, I'm there. But also my client, like in this case, he wasn't there, but he was at the other scene that y'all kept trying to paint. And he gave you where he was. He could only definitively be the real ID of what he could do or where he was and wasn't. So sometimes it works. Now, if you got a client you can't control, my other client I put on the stand the week before, sometimes he used to go on a tangent. Like he go get to telling a story, he mad, everybody corrupt and this and that. On the stand, I had told him, I said, be yourself. I want you to tell them exactly what happened that day, how it was. You curse, you say it with the same emotion, but you don't need to elaborate beyond that, because some things are just your personal feelings. You need to separate your personal feelings from what happened that day, and I need you to be the person to tell them the truth. And he was like, all right. And he did very well. I've never had a client who went up there and did bad, because I explained to them, this is not about your feelings. This is not about you going back and forth with the state. This is about you telling the story from the only person that really the jury wants to hear from, because credibility is always relevant and we have to add in our credibility, and it typically works out sometimes. Some people do not need to go on the stand. My other client for the home invasion did not go on the stand. There was no need for him to talk, because as far as we're concerned, it didn't even happen. This incident is a lie. Right. And it was a lie. Right. So it was a made up event. So I was like, what are you adding if there was a lie? What story could you actually tell? Because nothing is truthful here. But if there's some level where they need to hear from your client, it's like, you need to say something.
That's very insightful. I think people from the public can take that away too. That look, sometimes you may have to testify, and even lawyers, especially lawyers, because a lot of times the client follows our guidance. And there's some people who have adopted the mindset of my client's not testifying ever. In this line of work, every case is different. The facts are different. The jury's different. What the people hear and expect to hear is different. So I think being willing to put the client on the stand, if necessary, takes a lot of courage. But if you don't have courage in doing criminal defense work, you're going to struggle to do it.
Very much. And always talk to the jurors if you can after, to hear what they really thought, because it's interesting to see if they believe that you put on the case, or if you were just so great, or whether the state was just not good, or whatever they think. Sometimes you'll find out that the jurors that you thought that were for the state instantly didn't like the state's case from the moment it came out of their mouth. Or you'll hear, like, they'll say, I didn't think your client wasn't guilty. I just thought that they didn't win the case. Like, you'll hear the thing. So it's like, they were like, they didn't put on the case and they didn't prove it. So I'm not going to convict them because I think he did it. I don't know if he did. They didn't give me enough to say he did. And I love that from anybody who's in criminal. I don't care what the win is or how it is. The point is that it at least showed that was what the jurors actually said in that case. In this one, they were like, we don't know if he did or they didn't. Some of us thought he did, some of us didn't. But what we did know is that the state did not put on a case to prove the case. And you showed us that. So as long as I showed them that they don't have enough to put together a case for you to present you with enough to make a decision, then you can't make that decision. So,
well, thank you for doing this. It was great talking to you. I'm sure the audience is going to love it. But more importantly is people who may need you in the future. How does somebody find you and connect with you if they need your services in the future?
So they can always email me at info, like INFO, at drummondlawgroup.com. I'm also, my pages are kind of open on social media. Just type in my first name, you'll find me. I'm the only one in the US, I promise you, with the name. You'll see two on Google. One say Marshall, one say Drummond. They're both me. But if you type in my first name, Yladrea, you'll find me and you can contact me like that.
All
You
right.
got
Well,
it.
this was a pleasure. I appreciate it. Keep winning so I can bring you back on.
Sounds good. It was fun. Thank you for inviting me.
Oh, no problem. Enjoy the rest of your weekend.
You too. Bye
All
bye.
righty. Bye.